Like we say, I have this book with me, Constitution of India. So let's start with discussing that what is this constitution. Like, this book is here. A lot of people talk about constitution, like the country shall run as per the provisions of the constitution, as per the articles and schedules of the constitution. So what do we mean by constitution? How did we get the constitution, and how did it all start? So to know that, to assess that, we need to go back at least 100 years. It all began, we can say, with Simon Commission. In 1927, a commission came to India, and that commission was to decide the future of India, because India had been colony of Britain for almost 2 centuries, and there was a lot of talk. There were so many movements that something should happen to India. A lot of people were demanding dominion state for India. Some people were demanding something else. So there was a lot of talk happening. What should be done? And amidst all that, Simon Commission comes to India. Simon Commission was all white. Simon Commission didn't have a single Indian. It had 7 members, but not a single Indian was there. So there was a lot of resentment in India. Simon go back, Simon wapas jao. Those slogans met Simon Commission at every place in India, wherever they went. There were a lot of protests. And in Punjab, those protests were being led by a very well-known leader called Lala Lajpat Rai. Lala Lajpat Rai was leading the movement. And there were a lot of student leaders. You might be knowing their name: Bhagat Singh, Sukhdev, Rajguru, Chandrasekhar. They were also there on those protests, and they were very peaceful. One fine day, police comes and they lathi charge. And in the lathi charge, what happens that Lala Lajpat Rai gets hit by sticks, and eventually, unfortunately, he passes away. And then it angers youth of India a lot. It angers and saddens everyone, but youth was very angry. And it leads to a lot of consequences, which we are all well aware about. It's in common parlance. That pressurizes the mainstream political party of India, that's called Indian National Congress. The National Congress initially was talking about dominion status, gets compelled to talk about Purn Swaraj, entire independence, full independence. And that full independence eventually is celebrated on 26 January 1930 as Independence Day in India. Processions are carried out, national flag is hoisted. And the country promised to itself that, okay, we don't have independence today, but whenever we get independence, we will treat this 26th January as a nice day. Time moves, then cabinet mission comes to India, and cabinet mission in 1946 proposes that let's have a constituent assembly. It was supposed to serve, and it eventually served 2 purposes. One was of constitution making, another was of being a supreme legislature of the country. So 2 purposes were entrusted to this body. Eventually, India got partitioned in 1947, and the Constituent Assembly continued its work. It worked through various committees: advisory committee, drafting committee. And drafting committee, in fact, was headed by Dr. B.R. Ambedkar. On 26 November 1949, Constitutional Assembly adopted, enacted, and gave ourselves the Constitution of India. And to respect the promises of the past, the sacrifices of the past, 26 January 1950 became the official day to adopt the Constitution. So I took these 5 minutes to give you this introduction, that how do we have this Constitution like. So we have this Constitution because so many people made so many sacrifices for us. And now we have the Constitution. It has multiple parts. So Constitution of India, how many parts it has? It has 22 parts. It has 394 articles. It has 12 schedules. So this is the structure of Constitution, and Constitution begins with preamble. Preamble, we can say in simple words, is a small summary of Constitution. Like, all the provisions are aimed to achieve the objectives prescribed in the preamble. And preamble talks about justice, principles like justice, liberty, equality, fraternity. And if you see Constitution in India, these objectives find their place in fundamental rights given in Part 4, directive principles of a state policy given in Part 4. And in multiple provisions, you will find these aims and objectives getting a place. So this is what Constitution of India in summary is to begin with. Now let's come to the topic of the day, which we are tasked with to discuss the topic. So the first topic is Article 226 and Article 32. What are these articles? What do they do? Why are they so important? So to begin with, Article 32 of Constitution of India is found in Part 3 of the Constitution of India. And Part 3 of the Constitution of India is, anyone, any input? Any input? Part 3 of the Constitution of India is fundamental rights. So in fundamental rights, there are multiple rights which have been given to us. And those rights can be classified in broad 6 categories. First category is right to equality. Second one is right to freedom. Third one is right to freedom to religion. Fourth one is cultural and educational rights. Fifth one is constitutional remedies. So these are the rights granted by fundamental right provision. And in that particular part, we have in the last part, right to constitutional remedies is Article 32. Dr. Ambedkar called this part as soul of the Constitution of India. So what does this article do? Why people call it so special? There are so many rights even in the Constitution, but the rights given in the Part 3 are guaranteed. Their enforcement is guaranteed. They are not mere lip service. So if your rights granted by Article Part 3 of the Constitution, fundamental rights, are violated, then you have a fundamental right under Article 32 to approach the Supreme Court of India, highest court of the country, and seek remedies. I will go to Article 32 of Constitution India for the clarity. It has 4 sub-articles. The first one will read, the right to move to Supreme Court by appropriate proceedings for enforcement of the rights conferred by this part is guaranteed. So it is a guarantee that if the rights granted by Part 3 are violated, this particular article of Part 3 gives you guarantee to go to Supreme Court and get a remedy against the violation. 2 says that the Supreme Court can issue any order, direction, or writ. I will come to writs later. And the Part 4 is important because it talks about suspension, that can this right be suspended? So it says the right guaranteed by this article shall not be suspended except otherwise provided for by this Constitution. So the right granted by Article 32 is guaranteed and it can't be suspended unless provided by this Constitution only. And where the suspension is provided for, it's provided in Article 359 of Constitution of India. There are queries. Let's assemble them. I will address them once the turn comes. Let's try to go through all the topics once. And once we are through the topics, Mr. Gupta, I will address these queries one by one. So Article 359 is an exception. So let's see what does Article 359 says. So I'm reading from Article 359. It says, where a proclamation of emergency is an operation, national emergency, Article 352. When President says during the war or armed rebellion, internal problem. In those 2 situations, earlier the situations were really wide. Then the emergency taught us lessons and amendments were made. So now war and internal rebellion, these are the 2 grounds on which national emergency can be declared by the president. And once this emergency is in operation, president may by order declare that the right to move any court for the enforcement of such rights, the rights conferred by Part 3, except Article 20 and 21 as may be mentioned in the order, and all proceedings pending in any court for the enforcement of the rights so mentioned shall remain suspended for the period during which the proclamation is in force or for such shorter period as may be specified in the order. So it's quite clear that during the emergency, enforcement of the fundamental rights can be suspended. Fundamental rights per se are not suspended, but their enforcement is suspended. So they lose their force. They lose their sanctity. But two rights can't be suspended. And what are those two rights? Article 20 and 21. So what's so special about them? Why they can't be suspended? Because they go to the very root of this republic. 21 has like very limited lines to it, but every time I read these lines, it sounds like music to me. I will read it for you also. No person shall be deprived of his life or personal liberty, except according to procedure established by law. So life or personal liberty cannot be taken away except according to procedure established by law. These last four words get defined in Menka Gandhi. We will discuss that in detail. So that's Article 21, and 20 has three parts. First part is ex post facto law, that you can be convicted for an offense and the sentence can only be equal to the sentence prescribed on the day when the offense was committed. Later on, the sentence cannot be increased in the book and you can be granted the enhanced sentence. This can't be done. That is first provision, first subclause of 20. Second subclause is right against double jeopardy. No person shall be prosecuted and punished for the same offense more than once. And the third one is no person accused of any offense shall be compelled to be a witness against himself. So you might have seen Hollywood movies wherein a cop comes and says you have the right to remain silent. He is talking about Article 20 subclause 3, that you have a right against self-incrimination. So these are the two rights which won't even be suspended. Their enforcement won't even be suspended during the national emergency. So these rights are rarely sacrosanct. So this is about Article 32. Now I will come to Article 226. 226 is to be found in Part 6 of Constitution in India under Chapter 5. So it begins, 226 begins with a reference to Article 32. It begins, notwithstanding anything contained in Article 32. Every High Court shall have power throughout the territories in relation to which it exercises jurisdiction to issue to any person or authority. Any person or authority, including in appropriate cases any government within whose territories, directions, orders, or writs, including writs in the nature, all writs defined, enforcement of any rights conferred by Part 3 and for any other purpose. So there are two things which are happening extra in 226. First thing is that it's applicable on any person or authority. So it widens the scope, because 32 remedy is for fundamental rights only. And this remedy specifically says it's for fundamental rights plus for any other purpose. And that any other purpose gets defined in multiple judgments. So these two things are there. And as far as territoriality is concerned, it says two things: that cause of action has to be in the state wherein the High Court is situated, or cause of action should be there, or the party, authority, person against whom you seek order, writ, direction has to be situated in that particular High Court. So in these two manners, the concerned High Court gets the jurisdiction. So by seeing both the provisions, one thing is quite clear: except the territorial jurisdiction, the 226 remedy is broader, though it's not guaranteed, but it's broader than 32, because 32 is confined to fundamental rights only. 226 goes beyond that. So 226 is broader, but it's local in its approach. So that was about 226 and 32. Moving forward is types of writs. So type of writs, like we have 5 types of writs. Writs have been like, writs are not invention of Indian Constitution. Writs have been there. They were there in the common law in England. They were used for a long time. So basically we have 5 writs. The first one is habeas corpus. It means you have the body. So whenever a person is missing, unlawfully detained, in all those situations, a writ of habeas corpus is filed. As the writ is concerned about human body and liberty, obviously police will get involved. So there is this writ is of criminal nature. It's a criminal writ. So this is writ of habeas corpus. In habeas corpus, there is a very famous or infamous judgment of ADM Jabalpur during the emergency, because during the emergency an interpretation came from a constitution bench of the Supreme Court, which was eventually overruled not very late from today. So habeas corpus jurisprudence is there. So basically, this writ is preferred whenever a person's liberty is in danger, whenever you don't have the person's body or a person's bodily rights are being deprived unnecessarily, arbitrarily. That's the first thing. The second writ of mandamus. It says the translation is mandamus, meaning is we command. So it means if any authority, public or private, has a public duty, a public function to perform, then the concerned court can grant a writ of mandamus against that body to you. Third one is prohibition. Prohibition is preventive in the nature. So if something wrong is happening, some court or tribunal is doing something which they are not supposed to do, which they are not ought to do, in those situations, writ of prohibition comes in. It's preventive in the nature. Writ of certiorari, on the other hand, is used after the matter is over to be certified. It can be used on the ground of law, jurisdiction. And then finally, we have writ of quo warranto. It says by what authority. So to invoke this writ, you need to have a public office and a dispute about right to this public office. So it simply means by what authority you hold this public office. So now, yesterday only, India's public office, a very respectable public office called Vice President of India, became vacant. Now, who will hold the office? How the election will be conducted? These are the debates which could we have. But anyone who holds that office in future, if he holds without the due process, then this writ can lie. So this is the writ of quo warranto. It's not used every day in common parlance. In common parlance, we say writ of mandamus, writ of habeas corpus. But quo warranto is something when it's used, the consequences are huge. And then comes the next part of our discussion, maintainability of a writ petition. So yes, how does your writ petition becomes maintainable? So as far as the writ petition in Supreme Court Article 32 is concerned, we know it should be about fundamental rights. But as far as the writs in high courts are concerned, those writs have to predominantly show that against the body, against the person they are seeking the writ, that person performs a public duty. And that public duty aspect is very important. It need not necessarily be a government thing. It needs to perform a public duty. We will later on come to the judgment, the Anandi Mukta Sadguru judgment. It's in the compilation. I will come to it. It will simply say that why the public function is giving precedence over the character of the institution. Institution's character is not very important. The work the institution does, if it's a teaching institute, then it has some public duty attached to it. If it's a hospital, it has some public duty attached to it. So the duty and the function has to be seen. So that is the one ground of maintainability of a writ. Another ground of maintainability of the writ, who can file, is the locus standi. Who can file it? A person aggrieved. The simple answer is that if a person is aggrieved, then the person can file it. But as the republic had its march, as the country moved after independence, after adoption of the constitution, we realized that a lot of our brother and sister could not approach the constitutional courts because they did not have the means. But they suffered. In Bandhua Mukti Morcha, there were bonded laborers who were working like slaves. So now what to do? In this situation, Honorable Supreme Court came up with the solution of relaxing this rigidity of locus standi. And it said that if a public interest is involved, and if the petitioner shows the bona fides that he is here for the betterment of the society, then the locus standi would be relaxed, and the person can seek the redressal of the issues raised. And this is how the public interest litigation was born, with this great objective. And the third aspect of maintainability of the writ would be alternative remedy. Basically, if you see in today's time, In today's time, we have so many tribunals. Consumer courts are there. There are tribunal. We have Central Administrative Tribunal. It's a tribunal. We have National Green Tribunal. So there are so many tribunals. So those tribunals give you very specific remedies. So if you are a consumer, see, today you buy a laptop on Flipkart and the laptop is not of good quality, you can sue Flipkart in consumer court, and consumer court can pass orders. But what if that consumer court passes an order against Flipkart saying that you give compensation of 5 lakh to the consumer? And rather than filing an appeal, which is given in Section 41 of Consumer Protection Act 2019, Flipkart goes to High Court, Territorial High Court, saying that in 226 writ, you quash this order because it's bad in law. Now, in that situation, the High Court will say that it's not maintainable. Why? Because you have an alternate remedy. You go to Appellate Tribunal of District Consumer Forum, that is State Consumer Forum, SCTRC. You go there, you seek the redressal, you have a redressal. So why you are coming here? If we allow you, there might be a docket explosion in our place. There are a specialized body dealing with it. Let them deal with it. So alternate remedy concept is there. This concept has an exception that when alternate remedy can be shown to be ineffective, then the person could be allowed to approach to the concerned High Court in 226, even when they have the alternate remedy. So this was about maintainability of a writ petition. Territorial jurisdiction, as we have been discussing, it simply means where the cause of action is there, as far as high courts are concerned. Supreme Court has in 32 jurisdictions across the country. All they need is violation of fundamental right, and they are bothered with that only. So as far as violation of fundamental rights are concerned, Supreme Court could be approached and Supreme Court will be providing the remedy. As far as high courts are concerned, their jurisdiction is wide, but their territorial jurisdiction is limited to the area they are in. So first is territoriality. If the body is situated in their territorial limits, they will have jurisdiction over the issue. And second is cause of action. So if the cause of action is a bundle of facts which constitute a particular dispute. So if the cause of action is in that particular territory, then the concerned High Court has the jurisdiction, and or the defendant at opposite party resides there, then the High Court has the jurisdiction. So that is about the territorial jurisdiction of the High Courts. Now, the most important thing and a very interesting topic comes in, that's about judicial review and judicial activism. Now, what is judicial review? Judicial review is something which has been in the contention and discussion for long. Simply, it means court's overview. Court's overview to check the constitutionality of executive action as well as legislative action. So court reserves the right, if some executive action is questioned on the ground of legality, rationality, procedural propriety, then courts have the right to intervene. But the test, the Wensbury test, which is commonly known as test of unreasonableness, has to be seen. So the action has to be very unreasonable from aforesaid. Then only the courts will go into it. Otherwise, they won't interfere. And then comes the legislative actions. Same happens with the legislative actions, that multiple acts get challenged. Aadhaar Act got challenged. Eventually, it resulted in Swami judgment of 9 benches. So acts get challenged. Even constitutional amendments get challenged. So there was a constitutional amendment through which National Judicial Appointment Commission came in. It was a constitutional amendment. Supreme Court struck it down. So the power which judiciary has are immense as far as this judicial review is concerned, because it's believed that by this power, by exercise of this power, the sanctity of the constitution, the sanctity of the system is preserved. What is judicial activism? Judicial activism is an effort to fill the legislative and executive vacuum. So when the environment is falling day by day, the air is bad, when you can't breathe, AQI is in 500, 600. It can be said that government will take care, but when the government just doesn't take care, what will happen? Supreme Court steps in, and that's called judicial activism. We have a chain of MC Mehta judgments. You type MC Mehta judgments on Google, you have a plethora of judgments before you. Air pollution, water pollution, TAS. So it's taking care of the executive part. And then comes the legislative part. Vishaka judgment is an example. Sexual harassment at workplace. It was an elephant in the room and no one was willing to address it. So sexual harassment was rampant. Women were getting harassed day by day and no one was bothered. What to do? In that situation, Supreme Court came up with the guidelines. Supreme Court said that, okay, if a woman is getting sexually harassed at her workplace, it's violation of her right to life, right to profession, multiple rights, and we can't sit silent. So there was no law, there was a legislative vacuum, and Supreme Court in the Vishaka judgment drafted the guidelines of preventing the sexual harassment at workplace. And those guidelines were implemented in the entire country till we get the required law. So this is what judicial activism is. But there are critiques as well. Critiques is that Montesquieu, the philosopher, social philosopher, political thinker, he said that separation of power is at the bedrock of democracy. He says that legislative, judiciary, executive, they are all different. They need to remain in their confines. And when judiciary enters in these two fields, it violates that sanctimonious principle of Montesquieu. And a lot of discussion happens that why doing judicial activism is Supreme Court trying to enter in someone else's field. So that discussion is also there.